Hello guys, and welcome to Coin Lady channel. In the SEC versus Ripple case, Attorney Jeremy Hogan discovered circumstantial evidence suggesting that Judge Torres may not view XRP as a security. I will explain in detail why that is the case. In addition, I heard back on this issue from attorneys Jeremy Hogan and John Deaton. Alright then. This is a new tweet from attorney Jeremy Hogan, who has written the following. At least 3 times in her recent order, the judge referred to Marine Bank versus Weaver to explain what a reasonable buyer of XRP would have thought. The issue at hand in this Supreme Court case is whether or not the item in question was commonly understood to be a security. I'll just add that I appreciate all the lawyers in our community who explain these concepts to the rest of us laypeople, because most of us aren't lawyers and have a hard time making sense of it all. The implications of some of the information cited here and here are beyond our wits' end. 2 lawyers, Jeremy Hogan and John Deaton, explained the situation. So, Attorney Hogan passed along the following screen grab, which I'll expand to fill the screen for a moment. The disputed agreement is not the typical financial instrument that springs to mind when the word security is mentioned. This is from the case SEC versus W.J. Howie Company. Furthermore, VCM Joint Releasing Corp. distinguished the provision of the agreement giving respondents a share of the company's profits is not sufficient to make the agreement a security before the O and SEC. This may sound like gobbledygook to those of us who aren't lawyers, but thankfully they explain it for us. Read what John Deaton, an attorney, has to say about it. Read the language. He says, jumping into the conversation. The investors were promised a portion of the company's future earnings thanks to a clause in the agreement. On the other hand, the court ruled that the provision itself does not constitute security. This is one of the main points of the amicus brief filed by XRP holders. Both initial purchases of XRP and subsequent resales are not considered securities. So, it's clear to you now why this is such a big deal. This begs the question, why might Judge Torres cite this Supreme Court case more than once? Could it be that the underlying asset's classification as a security played a role in the court's decision in that case? In my opinion, that is the case. All of the amicus briefs were filed to say, essentially, hey, look at us over here with our hands raised, and this is why I believe what attorney John Deaton has done is of the utmost importance. We are a business that accepts XRP payments. This has nothing to do with making money. The anticipation of gain is irrelevant. The way we use it is functionally equivalent to spinning the bits or tapping the jets. Explain what it is that you do for a living. It's blatantly obvious. However, Judge Torres appears to have paid close attention to all of this. Very important in the grand scheme of things. Everything about this is enormous. Therefore, it's only a hint, but it's a pretty significant one. It's a huge clue. Then, in our brief, Attorney Deaton says, considering the inherent characteristics of the underlying asset, XRP is critical before conducting a Howie analysis, emphasis added. Next, he referred to the 1974 case of Glenarden Commodities, Inc. versus Costantino, which is the only one that directly applies. Again, XRP is essential before even getting to Howie because of the characteristics of the underlying asset. Again, I don't see the connection. Because, if you recall the case cited by attorney Jeremy Hogan, well, by Judge Torres, and then attorney Hogan notes it again here, John Deaton claimed that the investors were entitled to a portion of the company's profits thanks to a clause in the agreement. On the other hand, the court ruled that the provision itself does not constitute security. In and of itself, the underlying provision is not particularly significant. Then, later, attorney Deaton added this quote to the conversation. Instead, how the offer describes the instrument in commercial contexts is the litmus test. Prospective investors were enticed by the distribution plan and economic inducements, end quote. Finally, he says, the bottom line is that, quoting a famous saying. Then he gives us another one of his jokes. The case United House Founding vs. Foreman was heard in 1975, and this is a reference to it. According to the quoted text, the securities laws do not apply when a purchaser is motivated by a desire to use or consume the item purchased, and so on. That has real-world ramifications. So keep that in mind. In a very literal way, Attorney Dean stated that the securities laws do not apply when a buyer is driven by a need to use or consume the product. After digesting this information, Judge Torres presents the Supreme Court case at hand, in which the underlying asset or instrument, to be more precise, is discussed, along with the argument that surrounds it. Wow, that's significant. Now we have a clue as to what Judge Torres is contemplating. That was one massive hint. And judging by his response to Attorney Deaton, I gather that Attorney Hogan would agree with me as well. After reading the Daubert order, Hogan's attorney responded. The Daubert order, in which Judge Torres rejected numerous expert witnesses for the SEC, was issued just a few days ago. According to Attorney Hogan, the Daubert order suggests that the brief and submissions of XRP holders could prove to be pivotal. Exactly. That's exactly my point from a few minutes ago. All these amicus briefs, all these XRP holders, all these submissions, all these people explaining why they're doing what they're doing with XRP, all of this is significant. In any case, the current legal framework makes it abundantly clear that such transactions could not qualify as securities. This is contrary to what the law says. I'm confident the judge will deny the SEC's summary judgment motion as requested in writing, Deaton wrote in response to Hogan. When they had no choice but to give up their supposedly expert XRP holder. The question of whether or not the purchase of XRP was made with the intention of using it as a commodity is crucial. For this reason alone, the SEC's motion must be denied. Again, this is Attorney Deaton merely stating his belief that Judge Torres lacks the requisite expertise to rule in favor of the SEC's motion for summary judgment. There's just no way, in his opinion, that the SEC can win with the current rules. He just can't imagine it happening. Attorney Deaton argues that the case's outcome hinges on how aggressively Judge Torres attempts to settle the matter without a jury. Does she find the instance where Ripple sent a brochure to 100 potential investors in 2014, an unregistered securities offering, and then draw the conclusion that today's sales are not good? As a result, we can't say for sure how Judge Torres will rule, but it's still possible that Ripple's dealings with securities were improper or unregistered. But again, as XRP holders, as long as there is a way forward for XRP and XRP itself is not found to be a security, as would be the right way to approach this, then we are fine. Anyway, not that I'm against going out in a blaze of glory, mind you. In no uncertain terms. In my opinion, they are a positive contributor to the XRP community. But what I'm trying to say is that it's fine with me if they have to pay a fine or do this or that in exchange for their freedom, so long as they can fight another day. Afterwards, John Deaton, an attorney, added his 2 cents. I was given permission to file a motion to intervene by Judge Torres. She might have declined our offer from the start. The advice of many seasoned attorneys was that she would say no to my request. Not this time, she said. Ignoring the SEC's personal attacks on me, she ultimately agreed to give us amicus status in the case. She was eager to get our thoughts and opinions. You can see the magnitude of the change brought about by this now. For the reason that, and perhaps you could say, okay, maybe Judge Torres would have come to these conclusions on her own anyway. Maybe. If this is the case, then doesn't it make it much more likely that she did? The sheer volume of data and information submitted by the numerous individuals and organizations that have filed amicus briefs suggests that this is the case. There's simply no way she didn't see it. The question is whether or not she would have noticed otherwise. Maybe. But at this point, she must surely have noticed. Right, that's exactly my point. As a member of the XRP community, Attorney Fred Rispoli responded to Attorney Hogan's letter with the following. His words were, "This is yet another reason I'm not 100%. The odds are against Ripple winning completely. Even so, I give it a 10% chance of happening." However, Judge Torres cautioned SEC repeatedly that they could lose the case at summary judgment. All that waiting. Even though the odds of Ripple prevailing at summary judgment are low, he believes that Attorney Rispoli can help them. Aside from that, he's also a lawyer, and he's among the lawyers who believe that a jury trial is more likely now as a result of what happened with the Daubert rulings, along with, including lawyer John Deaton. And so we really may see that there are increased odds of that, but increased odds in combination with Judge Torres seemingly understanding the importance of recognizing that the underlying asset itself is not a security, which means if that hint is what we think it is, then in the end, however messy this gets, however long it takes, the ruling is going to include something. If we interpret this hint as I do, then XRP will gain some much-needed positive clarity. It's likely that things will get better from here. In other words, that's why I decided to film this. That's the thrilling part about it all. There's no assurances, but that's a huge hint that could prove crucial. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making any financial decisions. It's all over today. Please like and subscribe my channel. See you later, bye.